Well, the U.S. Supreme Court is taking on affirmative action when it comes to college admissions. Lower courts have ruled race-based decisions help with diversity on campus, but some Asian Americans say the concept has actually hurt them. Thanks for staying with us at 5:30. I'm Curtis Ming.
And I'm Adrienne Moore. Our news is also streaming live on CBS News Sacramento right now.
All right, Brian Socek from UC Davis School of Law joins us to explain what this case really could mean for California. Now, Brian, give us the Cliff's Notes version of the case the Supreme Court agreed to hear today and how Asian Americans have felt slighted.
The Supreme Court took two cases today, actually. They're both related. They're both asking whether affirmative action is going to continue in higher ed admissions. One case was against the University of North Carolina, asking whether affirmative action is constitutional. And then since the Equal Protection Clause doesn't apply to private schools, there's a second case against Harvard University, asking whether they're violating Title VI of the Civil Rights Act, which prohibits schools that take federal funding from discriminating on the basis of race.
So a lot on the table, clearly. You know, UC Davis was actually part of the first affirmative action case to actually go to the Supreme Court. For those who are not familiar with the case, can you tell us a little bit about what it was and how it helped shape admissions practices?
Sure. This was over 40 years ago now in a case brought by a man who had applied to the medical school at my university, UC Davis. The case was known as Bakke versus Regents of the University of California, and it completely divided the Supreme Court so that only one justice ended up writing the opinion that really has ended up governing affirmative action law for the 40 years since then. What Justice Powell said in Bakke was that universities can take race into account if they want the educational benefits that come from having a diverse student body. But in doing so, he said they need to follow the model that Harvard University uses, which is they take race into account as one of many considerations that are part of a holistic evaluation of applicants. So race would be considered much like playing the trombone or growing up on a farm. It's one of the many things that makes each applicant unique. The irony now, of course, is that the model that he pointed to of Harvard University is now the very school that's being sued.
And this is the school where Asian Americans have felt slighted. What is their argument?
Well, the claim is that by prioritizing certain minority applicants, they say that schools like Harvard are taking race too much into account, that they are trying to bolster their number of, for example, African American students, and in doing so, they're limiting the number of Asian applicants. The courts below, the lower courts, have questioned the studies that the plaintiffs have brought there about what effect it really has. But that's part of what the Supreme Court is being asked. And more importantly, the Supreme Court is being asked to decide whether all the times in which it has said that affirmative action is constitutional, which it did in 2003 and again in 2016, whether it's going to change course and say that it no longer is.
Well, based on the makeup of the current Supreme Court, what do you think is going to happen? And really, what could this mean for students here in California?
Well, they'll probably hear the case next term, which means we won't have an opinion here until probably June 2023. There are three new members on the Supreme Court, all appointed by President Trump since the last time the court heard this kind of case. And I would be shocked if the court didn't use this opportunity to do what conservatives have long wanted, which is to do away with affirmative action in higher education.
All right, Brian Socek with the UC Davis School of Law. We appreciate your time so much. We'll hopefully see you again here soon.
My pleasure.